You ever wonder what your homeowners association is really doing? Like what they're allowed to keep secret from you? Well, today we're going to dive into a wild legal case that started with one simple request for a document and ended up in a formal hearing over a single blacked-out page. And it all comes down to one big question. What can your HOA legally hide? Seems like it should be a simple question, right? I mean, in theory, homeowners have a right to see the records. But there are always exceptions, always loopholes. And this whole story, it hinges on just one of them. And it sets a huge precedent for what private really means when it comes to your community.
So let's get into it. This whole conflict starts out small, deceptively small. It all begins with just one couple, their HOA, and a really stubborn refusal to share one little piece of paper.
Okay, so here are our key players in this drama. First up, you've got John and Deborah Sellers. They're the homeowners just trying to get some answers. Then there's their HOA, the Crossings at Willow Creek, who are dead set on keeping this document under wraps. And finally, you have Judge Kowal, the guy who has to step in and sort this whole mess out.
And check out how fast this all went down. In August, the Sellers make a totally normal request. By October, just 2 months later, the HOA sends stuff back, but a key document is completely redacted. That one move forces their hand, and by December, they're in a formal legal hearing. That's a lightning-fast trip from a simple question to a full-blown legal showdown.
And what was this top-secret classified document at the center of everything? You're not going to believe it. It wasn't some sensitive financial record or a secret deal. It was a courtesy notice, a violation letter sent to another homeowner about using their ATV. That's it. The HOA blacked out the name and address, and that single act is what sparked this entire fight.
All right, so to really get why this one little page caused such a massive fight, we have to look at the actual law that's supposed to guarantee transparency, because it's a law with this built-in tension, a real conflict between your right to know and someone else's right to privacy.
So here it is, the legal tug-of-war at the heart of this case. On one hand, the law in Arizona is crystal clear. It says all financial and other records shall be made reasonably available. But, and this is a big but, there's an exception. An HOA can withhold records that are considered personal, health, or financial. And the HOA decided that this little ATV notice? Oh yeah, that fell squarely into the personal category.
And this brings us right to the million-dollar question. Or, well, as we're about to find out, the $550 question. Is a routine HOA violation notice really the kind of personal information that this law was designed to protect? The entire case hangs on the answer to that.
So this wasn't just some petty legal squabble. It was a clash of two really fundamental ideas, an individual's right to privacy versus the community's need for transparency to hold its leaders accountable.
Now, the HOA's argument was pretty straightforward. They basically said, look, this letter has a person's name on it, their address, and it talks about something they did wrong. By definition, that's personal. We have a duty to protect our members' privacy. It makes sense on the surface, right?
But the Sellers saw it from a totally different angle. Their whole point was about fairness. They were saying, how can any of us know if the HOA is enforcing the rules equally if every enforcement action is a state secret? This wasn't about being nosy neighbors. It was about making sure the people in charge were actually doing their job.
So with two really compelling arguments on the table, it all comes down to the judge. And what's so great about this is that Judge Kowal didn't get bogged down in a bunch of legal jargon. Instead, he just applied some clear, step-by-step, common-sense logic that anybody can follow.
Let's walk through his logic, because it's pretty brilliant. First, he says, when you join an HOA, it's like signing a contract. Second, a huge part of the HOA's job is to enforce that contract, the rules. And third, and this is the kicker, for members to know if the job is being done right, they have to be able to verify the records. So it follows that enforcing the rules isn't some private, personal thing. It's official community business that affects everyone.
Next, the judge drills down on that word, personal. He reasons that the law wasn't written to protect every little tidbit of information about a person. No, it was specifically designed to protect the kind of sensitive stuff that any reasonable person would obviously expect to be kept private.
And he gives some great examples. We're talking about things like your social security number, your date of birth, maybe your vacation schedule, or sensitive health or financial data. That is the kind of stuff the personal records exception was created for. A simple notice about an ATV violation, it's just not in the same league.
And this leads him to his big conclusion. When an HOA sends a violation notice, it's not having a private chat.
It is performing an official act as a governing body, and that means it is official business. And just like that, the HOA's entire argument for secrecy just completely falls apart.
So, with the main question settled, the only thing left was the official ruling, and figuring out what it means not just for the sellers, but for homeowners everywhere.
The verdict was clean and simple. The crossings at Willow Creek HOA broke the law, period. They violated the statute when they refused to hand over that full, unredacted notice.
And the judge didn't just stop there. He issued a direct order. The HOA had 40 days to provide the complete document. No more games. And because the sellers won the case, the HOA also had to reimburse them for the money they spent to file it in the first place.
And the total bill for the HOA's decision to hide a single page? $550. That's a real, tangible price to pay for choosing secrecy over transparency. And it's a clear win for the homeowners who decided to stand their ground.
So why does all this matter to you? Well, the takeaway here is huge. This case confirms that keeping your HOA accountable isn't just a nice idea. It's your right. You are entitled to see how the rules are being enforced, because making sure everyone is treated fairly is the business of the entire community. It's the foundation of a healthy HOA.
Which brings us to one last thought. This entire legal drama, this whole fight, it only happened because one family decided to ask a simple question and then actually followed up. It kind of makes you wonder, doesn't it? What's in your HOA's records? And are they choosing transparency or are they choosing secrecy?